The National Student Financial Aid Scheme says it has completed all payments to university and TVET college students for the 2024 academic year. It says this was done against valid registration records received on the 15th and the 19th of March. But some students say they haven't received their April allowances. NSFAS spokesperson Ishmael Mnisi is joining us now for some clarity on that. Ishmael, good to have you. Thank you very much for coming on. What do you mean when you say you have paid all allowances?
Good evening, Thabo, and to the viewers. When we are saying we have paid all allowances, we mean allowances against the registration data that NSFAS has received from our universities and TVET colleges. In your introduction, you mentioned the 2 dates, very important dates. That is the 15th of every month for TVET colleges and the 19th of every month for universities for them to submit the registration data that will allow us to pay allowances to these institutions. So now we have paid all of those that have submitted the registration data, except, of course, 12 universities and 2 TVET colleges who have not as yet submitted their registration data.
Does that include the Tshwane University of Technology?
Certainly, it includes the Tshwane University of Technology. However, what has happened, Thabo, is that the majority of them have already submitted after the 19th of every month, as I've indicated. So we do have the data for some of these institutions now. However, they could not meet the cutoff date.
So the fault you're saying is on the side of the universities or institutions, let me put it that way, who did not meet the cutoff date. And does then, therefore, that affect your disbursement run and the rollout of it? Because we spoke to students just at the top of the month of April during the just after the Easter period. They say they are returning to schools and they don't have money. In fact, they are not returning to schools because they have not been paid.
Certainly, the challenge with the institutions who did not meet the deadlines, of which they know very well. They were communicated to them. They are not new deadlines. However, the data was not submitted on time. But I must indicate, Thabo, that NSFAS is cognizant of the challenges of all the recipients of our bursaries, that they are affected by this challenge. And we are, at the moment in discussion as an organization as to how can we possibly look at assisting all of these institutions which have now submitted data. However, it has its own challenges and a decision is yet to be made on how we can intervene going forward.
So as we sit now, Ishmael, I mean, one of the students said, well, they suspect that the so-called e-tech companies that were suspended were actually back dispersing funds again. So as we speak now, are those suspensions still standing of those e-tech technology companies that were dispersing funds?
No, we did indicate in our statement by the board a month ago that the fintechs will start to disperse allowances with the April allowance. So NSFAS is working with them, with the institutions that they've always been working with to disperse allowances. So as we are saying, the challenge would not be with the fintechs in this regard, but it will be with the data that has been submitted to NSFAS, because we appropriated money as NSFAS to the fintechs based on the registration data that we have received. Now, in instances where we have not received that registration data, fintechs would not be in a position, of course, to disperse the allowances to those institutions that they have not submitted.
But why were those contracts suspended in the first place?
You'd recall that there is no suspension of contracts with fintechs, but we made the upfront allowance payment of allowances beginning of this year based on the fact that the registration data from institutions had not been submitted at that time. So we therefore made arrangements for the February and the March allowances to be paid directly by institutions. We came up publicly to announce
Hold on. 19 October, didn't you issue a statement that the 4 fintech firms, being Coinvest, Izaga Holdings, Norako Corporation, and Tenet Technology, those contracts were terminated?
No. We said in our statement, we said there is a report, the Werksmans report, which NSFAS is currently finalizing the legal processes towards the termination of this contract based on the report that was issued by this law firm. We know that their appointment is suspect at the moment, and we said at the time when our legal processes have concluded, NSFAS will make further announcement in terms of how we will disperse our allowances going forward. But at the moment, the challenge for this year was the registration data, which we did not receive from institutions in February and March, and understandably so, because registration processes were still underway in the majority of institutions. As a result, NSFAS dispersed money to institutions for them to be able to run the February and the March disbursements.
Yeah.
And we then indicated that this arrangement was temporary for these 2 months. When it comes to the April disbursement, it will be done through the fintechs. And this is exactly what we have done in this regard.
But are you bringing back the fintechs without having given us a report of what your findings were? You have not concluded that process.
Remember, NSFAS has not as yet terminated the direct payment service providers or the fintechs.
Indeed, but you were investigating those contracts. You were investigating those contracts because there was suspect maladministration and how those contracts were facilitated and a hand of some of your executives that could have been heavily seen there in terms of how those fintech companies were appointed. So you have not concluded that process. You have not come back to us. There was conflict of interest in the appointments and so on and so forth. And you just bring them back.
Thabo, we never stopped the fintechs from doing their work because there is a legal process underway. You know that we have rules or laws in South Africa that even that governs supply chain, that when you have to terminate a contract, you need to follow due process, because if you don't do that, you are likely to be challenged, and that might even delay the very same process that we are talking about. Yeah. So we have indicated in our communication before that we are currently having legal processes underway that will lead us towards the final termination of these contracts. Yeah. However, we cannot do it outside the legal parameters because we do not want any comebacks when it relates to these processes. And secondly, Thabo, we have already started to implement the Werksmans attorney's report.
Yes.
You would know that we have suspended the then CEO, and ultimately he was fired on the basis of that report. Currently, there are staff members internally who are being subjected to the disciplinary hearings as we speak. Yeah. Those processes are also underway and inclusive of the contracts that we are discussing now of the direct service payment providers.
I must have missed that statement, Ishmael. Let me take a break because I don't want to rush you. I want you to explain to me exactly what has happened there. I missed that communication from your last communication around the service providers. Let's take a break. Ishmael Mnisi is joining us there, speaking on behalf of NSFAS. We'll wrap up the conversation with him in a moment. We're back with you, still with us, NSFAS spokesperson Ishmael Mnisi joining us for more on that conversation around the disbursement of the April allowances. So Ishmael, just take me back a little bit. So you're saying from October last year, when the chairperson, who's now of course has stepped aside, said we had an investigation, a Werksmans investigation. The scope of this investigation included probing whether there was conflict of interest in the appointment of the service providers. We are reviewing the NSFAS supply chain policies and procedures and the legal compliance of the procurement system. From that work that needed to be done, right? what decision was taken by the board that said, fine, while this work is being done, we are going to bring back these fintech companies to continue?
Well, let's explain that, Thabo. The board pronounced that they are going to implement the recommendations of the Werksmans attorney's report completely. And there are a number of things that are contained in that report. And as I've indicated earlier, amongst those are the internal disciplinary measures of NSFAS staff members and also the implicated direct payment service providers or the fintechs. Now, the board indicated, as correctly so as we are saying, that they have decided to terminate these contracts. But in terminating a valid contract in terms of the law, you follow the very same law to terminate that contract. In other words, you cannot do injustices or even flout procedures to terminate something that we already saying that the processes that led towards it was flawed. Now we are following that due process in the termination of those contracts. Now this is the reason why we at the moment are still using the direct payment service providers, because we have not finally concluded that process that leads us to the termination of their contract. Yeah. Should we terminate this contract without following that due process, we're risking the courts rejecting the termination and setting aside these processes. Now, we are cautious about the legal steps that we are following to make sure that at the time when we have dealt with all the requirements by law of the termination of a contract, we would have followed all due processes so that there are no comebacks. So we are still using the fintechs because the processes are not fully completed.
Yeah. So let me in simple terms, you're saying the Werksmans report could, even though you are committed to implementing its recommendation, see you having some legal comebacks if, for example, you cut off or terminate the contracts with the fintech companies, even though you believe that those contracts could have been entered into irregularly. Are you not then continuing that irregularity by continuing to use them?
Thabo, there are due processes when you're dealing with any legal matter, and especially the law of contract exists in South Africa. And as a state institution, we would want to observe all those laws that exist that governs the work that government is doing. Now, we are following those processes with the direct payment service providers. We are following the very same processes with our own internal staff members who have been flagged by the report itself. Now, we are not flouting any of those processes to make sure that when a final determination is made in terms of either the termination of employment of the staff or their suspension or any other recourse that will be arrived at, we would have followed due process. Now, equally, with the direct payment service providers, we are following the very same processes in dealing with the contracts themselves. And as I'm saying, we do not want to flout any procedures, court procedures, so that when ultimately a decision is made, NSFAS and government is not found wanting in terms of the termination of these contracts. That is the reason why we are still currently using the service providers as they have been appointed since the existence of this contract.
Okay, I'm going to try one more time. So let me put it this way. The SIU goes in and it investigates a particular entity, and it says this contract was irregular and this contract must cease to exist. That contract is terminated immediately. The department doesn't say, no, well, the contract will continue, we'll still use that service provider. You know, and you are saying to us that you have a report that says this contract would have been entered into irregularly, but we are going to continue because if we terminate it, we're going to get sued.
Now, this is what is happening. The SIU is an investigating body, is not a prosecutorial body. Now, what they will do, they will investigate, have a report, and take it for prosecution. Now, it is the public, the prosecuting authority, the NPA in this instance, that will then begin the processes of dealing with that part of the competency. Even in this instance, a report that has been sanctioned by the board has been presented, recommendations have been made, NSFAS makes a decision that it will implement all those recommendations. Processes, legal processes currently have been commenced, and that we have committed ourselves to. We are almost towards even the end of some of those legal processes. After we have completed those, we will then be able to confidently terminate this. Remember, the report that has been given by the Werksmans attorneys can still be interrogated or challenged by the very same companies, and that is why we are following that procedure to make sure that we don't have comebacks. Okay. The last thing, Thabo, that we would want to do is to rush towards the end process without following due procedure, because that on its own will prolong this process, which we believe as NSFAS it should not be prolonged if it's done properly.
I appreciate your time. Ishmael, thank you very much for coming on, speaking on behalf of NSFAS there. Ishmael Mnisi. I'll be back with the latest.